You may also take a bite on this before we get into the big issues for this morning.
Okay. Yeah. Can you hear me?
Yes, loud and clear.
Okay. Yeah. So what I want to say first is that I'm a bit surprised that Lawyer Braco can say that essentially the Attorney General is misleading the public. I think Lawyer Braco, you are a lawyer. The Attorney General is a lawyer as well. So for him to have said clearly that he had been working with the American authorities to get the visa revoked, and then you can say you don't believe so, it appears it's a bit, it just doesn't jive. The Attorney General represents all of us. So by the time you say you don't believe so, you should give us at least some basis. Because he was very clear that he had been working with the U.S. authorities to get the visa revoked, right? Right. So it just didn't happen. And you are saying no. Meanwhile, you are not giving us any basis on which his statement is false. I think that one is, let's look for a way to deal with it. I think we shouldn't just lightly brush aside official statements by public officers. We can't do that. Even in the previous regime where we saw Godfrey Dame saying on tape that he was being asked which hand Atta Forcing and Ofori Atta, Japa. Subsequently, we weren't brushing his statements aside like that. Much less Dr. Ayene, who has not been caught in any unethical conduct. Between the two, you, Braco, look at the date. A year before MPP left power, the Attorney General, Godfrey Dame, had been caught on tape, engaged in very unethical conduct. Yet 1 year, it took about a year and a half before they left office. I never heard you say anything that he had said to be false publicly. So I think you should hasten slowly. You may disagree with the Attorney General, but before you do so, kindly come with your own basis. But it is not a democracy that a public officer that we've given our resources to champion our cause comes to tell us with our resources that this is what he's done. And then a citizen will just come, a lawyer at that will just say, oh, it's false. It doesn't, you should have basis.
All right.
Before saying it's false. Okay.
All right.
Yeah, so that's what I have to say on this particular matter. And that, listen, I want to repeat the call that the MPP and the Kufuado must prevail upon Ofori Atta to come down voluntarily. We don't have to wait for any extradition. What is our crime as Ghana or as Ghanaians? That we voted for them to come and administer this country. They got all the privileges, traveled all the best classes, enjoyed all the hotels, all the respect, everything, all the privileges for 8 years. And then, as a sign of payment, what they are doing to us today is to embarrass us internationally. Because now, with everything that's going on, say that our country is not safe for Ofori Atta to come back, etc. And the whole point that Ofori Atta is in a foreign jail embarrasses Ghana. It embarrasses Ghana. So the MPP is really serious about coming back to administer this country someday. They should publicly come out, tell Ofori Atta to come, and also privately send emissaries to go and enforce that, and inform us as Ghanaians. The same thing Akufo-Addo must do, because Akufo-Addo is Ofori Atta's brother. Look, Nashoko, in Twi, okay, there is no word for cousin. In our traditional setup, in Twi, your cousin is your brother. So Ofori Atta is Akufo-Addo's brother, right? So he has that duty to prevail upon Ofori Atta to come and must inform us that this is the effort he's taking. Then another salient point we must make is that I've heard some lawyers mixing up the issues about why Ofori Atta has to come. Now, among others, there is a constitutional duty for Ofori Atta to attend the trial. Please, Nashoko, let's separate them. I'm talking about attending the trial. That one is a constitutional duty. As for coming to help investigators, like he will confess, he will show them where this and that lies, he is not obliged. But as for the attendance, it's a constitutional duty. In Article 19, Clause 3, it says that the trial of an accused shall take place in his presence. Shall. It's a duty. That is a must. He must be there. Then he gives the exception, unless where he makes it impossible. So like he's being rowdy, that's distracting the court, etc. And then like when he has absconded. So absconding is not a positive, what do you call it, behavior. It's not a positive act of a citizen. That's deviance, right? So reading Article 19, Clause 3, there is a duty that he shall attend, right? Because the state is trying to get into the bottom of it. So you should attend so that it helps to give that sense of a fair trial, because a fair trial generally would involve that, among others, he should attend and be asked questions. If he doesn't want to answer, then he can say, I'm not answering.
But
so he has a duty.
Martin, we've had other lawyers also say that it's not necessary for him to be present. In fact, we've had many lawyers say that he can be tried in absentia. He doesn't have to be present for this trial to take place. This is something we've heard repeatedly. Is this incorrect?
Yes, that's what I'm saying. It's incorrect. So let me repeat. You see, what we are saying, there are different strands of obligations we are talking about. The one he doesn't owe an obligation is to tell the state that, oh, yes, I did this wrong. The evidence is here. It is there. Like the way sometimes you hear us say it loosely, he should come and help the state. No, it is the burden of the state to prove him guilty beyond reasonable doubt. That's the standard. Now, I understand. I know you are in training, but maybe I'll repeat for the lay persons. So it's beyond reasonable doubt. Prove the guilt of the accused beyond reasonable doubt. And that is the duty of the state, not the accused. If he wants to make things easy, he can confess, if only he did it. That's not what I've said. I'm talking about the trial. So you see, the Constitution says the trial shall be in the presence of the accused, and we are all citizens. So now the next thing, go to Article 12. You see that it says that, among others, companies in Ghana, organizations, state institutions, and natural persons shall respect. When you are respecting a law, it means obey it. So that Article 12 is part of the fundamental human rights, right? And a fair trial is part, Article 19 is part of the fundamental human rights. So Ofori has a duty to obey the law, respect the law, Article 12. Now, you can pull it and read, right? So that we can emphasize the point. Then go to Article 41. That place where you see this office, it shall uphold this Constitution, uphold the Constitution. So when the Constitution says that for a criminal trial, right, the accused shall be present, Ofori must avail himself. Now, Shoko, let's repeat. We are not saying when he comes, even if he doesn't want to talk, he must talk. No. The trial, so he comes, he's in court. Ofori, did you do this? No comment. Or if he likes, you just keep quiet. He has the right not to open his mouth. Yes, but he should come. So the duty in the Constitution is that he should attend he must attend the trial. As to whether he wants to talk, it's a different matter.
So if he doesn't come,
I'm sure
would he be breaking any law?
The American Express. Yes, he's breaking the Constitution. That's the point I'm making. The Constitution says that for a fair trial, one of the provisions for a fair trial is that his trial shall take place in his presence. Maybe we should pull it because of the, I'm not in the office, so I'm using my cell phone, so I cannot at the same time pull out the Constitution. But please, you can let one of the maybe Lawyer Bracco will have his Constitution there. If Lawyer Bracco can read Article 19, Clause 3 for us. It says that the trial shall take place in the presence of the accused. That's the rule. To every rule, there's an exception. So the argument I'm making is that the rule is that he shall be present. The exception is that if he comes to court and is making noise, he's being rowdy, etc., and makes it impossible for the trial to continue, then in that case, he will be removed. And when he's removed, that one is contempt of court. They don't just remove you and say, go home. Go. You'll be put in custody, right? Or if he absconds.
But it also gives the opportunity for him, the trial to take place in his absence if he refuses to attend court. And in this...
No.
May I
Now,
read
it's no
19.2
opportunity.
or 19.3? Did you say 19.3?
Yes.
19.3, all right. The trial of a person charged with a criminal offense shall take place in his presence unless A, he refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial. So in this situation, he refuses to attend court after he has been duly notified. If in this situation, if he refuses to attend, which appears to be the case now, because he is not coming, and from all indications, he does not want to come for whatever reason. All right.
Yes.
So
Yes.
if 19.3 clause A, 19.3A says it will take place in his presence unless he refuses to attend court for the trial to take place in his presence, isn't that the situation that is prevailing now? And isn't that why other lawyers are asking for the trial to take place in his absence?
Yes.
All right.
The trial will go on if he doesn't want to come. But I'm saying that the provision is saying that it shall take place. So we do it one by one. The rule is that it must take, that's the constitutional, it shall take place in his presence. If he refuses, it's not an opportunity, it's not a right they are giving him. If he refuses, it's deviance. He's deviating from the law. That's how come there are other laws. When he has refused, then we use force to go and bring him.
All right.
So if the refusal to attend was a right that he can exercise freely, and there will be no law on extradition.
All right.
And there will be no law on extradition. So it tells you that at all points we need him. So he must attend. So the people say he doesn't have an obligation to attend, they are dead wrong. Absolutely wrong. They've not read the Constitution well. It says he must attend. Article 12 says he must respect the Constitution. And the Constitution says that his trial in Article 19 says it must take place in his presence. And Article 41 says that as a citizen, he must defend and uphold the Constitution. So how do you uphold the Constitution when you are required to come to court and then you are somewhere refusing to come? You are breaching the Constitution. So please, let's repeat. Then also, let's assure him. I have said it that now, Shoko, I have gone to the Supreme Court on 3 different occasions. So you hear Pebu number 1 versus Attorney General number 1, Pebu number 2 versus Attorney General number 2, Pebu number 4 versus Attorney General number 4. They concern bail. I'm very passionate about bail. I will defend Ofori Atta if he comes here and anybody tries to, breach his right to apply for bail if it's not sent to court within 48 hours. Because you hear lawyer Kofi Benton says, Ofori Atta is scared that when he comes, he will just be locked up and then the key thrown away. No, Ofori Atta will be put before court within 48 hours. Nobody will make such an elementary mistake. Even if the papers are not ready, he will be put before the court and then the judge will be told that, oh, we are left with this and this paper. We don't have this document. Then the judge will assess and decide. We want to assure Ofori Atta that the fact that we are saying he must be held accountable doesn't mean that we are saying he should be dealt with anyhow. No, it will be due process. And me, I'll be leading the charges to make sure.
All right, Martin Pebu. All right, thank you for your submission on that. I was hoping it would be a short one, but thank you. We appreciate your input. We've been joined also in studio by Dr. Ramsey Inusa, our senior researcher, political researcher with the United Party, Director, Political Research, United Party. Let me put it properly. You're welcome to the show.
Thank you, Na. Good morning.
Good morning.
To you, and good morning to my brothers on this
Great
platform.
to have you.
Dr. It's been a while. I've had the chance to sit with him on the platform. So Happy New Year to him.
Happy New Year, my brother.
And it's good to be here.
Would you like to take a bite on the Ofori Atta matter before we get into our conversation for the morning?
Well, what I can say is that nobody is above accountability under the aegis of our Constitution and our laws. Ken Ofori Atta was indeed our previous finance minister. He conducted himself in a contumacious manner that caused huge losses to the public purse. I do not know why he's running away from accountability. This was the same person some time ago who joined the demonstration organized by Arise Ghana to ensure that then that previous Mahama I administration was accountable to the people. So what has changed? What has changed? This is absolute hypocrisy on its part. And I think that Ken should do the needful. He should come down. Indeed, I have argued that as some of us have lived in the diaspora for a while, now, there is no way you can be detained by an immigration authority when you are seriously ill. They made it look as if Ken was seriously ill that he could not even walk. That was a picture that was painted in the eyes of Ghanaians. But today, that lie by his people.
They said he was seriously ill. We
But
don't know.
the immigration, the hIS has been able to conduct a medical examination on him, and they said that he's fit to be detained.
To stand trial, yeah, and to be detained.
And
right.
so,
But it doesn't mean he's not sick at all.
No, but what I'm saying is that what they painted in the eyes.
That's the perception that
the perception most Ghanaians got, that Ken cannot even write with a pen. And so, indeed, he should take lessons from the Bible. And, you know, this is a person who has been reading Bible scriptures anytime he comes to deliver the national budget to Parliament. Indeed, if he's a practicing Christian, he should uphold to the norms and ethics of Christianity. And part of the norms and ethics of Christianity is to stand for truth and ensure that there is accountability and justice.
All right.
And so, indeed, if he's a practicing Christian, Ken should adhere to that, and he should come to Ghana and face the justice system.
All right. I want us to go to the matter for today, but I see that
quick one.
Braco Powers, you want to respond to what?
Quick one. I think this is a public TV station or media organization, and a lot of people are watching and some are listening. So it's important sometimes we put matters in their proper perspective. You know, Martin said that if Ken refuses to come to Ghana, he will be breaching the constitution or he will be a deviant. And I don't think it sits within the constitutional framework that we have. In fact, now articulately read the provision, particularly Article 19(3)(a). And I agree with him partly when he said that there's a general rule. The general rule is that in criminal trial, your presence is required. That's a general rule. But in constitutional interpretation, when you look at Article 19(3)(a), it has something we call a proviso. And proviso is a conditional clause that qualifies, limit, or create exception. So the Constitution itself has a proviso which creates an exception to the general rule that your presence is ordinarily or must be required. So when he says when Ken refuses to come, it becomes a breach of the Constitution, by which reason he had to even quote Article 41, which has to do with duties of Ghanaians. I think we are not doing.
So what's the proviso? The
proviso is that the general rule is that your presence is required during criminal trials. But you read it. When you refuse to show up, the court will take it that you have declined to appear before any of the judge, by which reason the court can continue with the matter. So that's a proviso. The exception to the general rule. So it's a conditional clause that even though your presence is required, it is conditioned upon you refusing to show up. So if you refuse to show up, that means that if you refuse to show up, the court will then proceed to hear the matter in your absence. So we shouldn't, be creating for.
So your presence is actually for your benefit.
For your benefit, because everything must be done.
If you refuse to show up, then
it means that
you have refused to enjoy the rights presented to you to be present at your trial.
That is the thing. So it doesn't amount to a breach of the 1992 Constitution, because the Constitution itself has created the proviso, the conditional clause. If you don't show up, then we'll proceed.
Okay.
So it should not be elevated. So let's not create faults in the minds.
So what you're saying basically is that Ofori's absence does not mean that he's breaching the Constitution or any law by being absent at his trial, if the trial should take place in his absence.
No. he hasn't breached any law, because there is an exception, as you well read, and strictly under Article 19(3)(a). So let's be able to put the message out to Ghanaians properly.
No, I also need a minute. You see, I don't think we should encourage a situation. A conversation like this. Imagine security officials or investigative agencies believe that somebody has significant levels of culpability or is a prime suspect in a matter. The person now decides to say that he has decided not to cooperate with security agencies, and nothing happens to the person. That's the conversation we want to encourage on this platform. I don't think that is.
That's not the conversation we're having.
That is the kind of
conversation we're having.
Hold on.
These are constitutional matters. You are doing politics on the matter.
Hold on.
You are doing politics on the matter.
Let me make my point.
That's not the
When we were
conversation.
talking, I was quiet.
No, you are doing politics on the matter.
No, hold on. Let me make my point. You sat here on this platform and alleged that an attorney general who has so many years of experience in this country has lied to the country without adducing any evidence that indeed the attorney general had not initiated any process in that regard. This is an attorney general that sat on a platform and said that a former attorney general of an American president, George Bush, you denied the attorney general's involvement with the person. You understand the point? And I think that it is very disrespectful.
No, but you should hold on. I didn't say he lied.
No, hold on. You said that the attorney general lied to the state.
No,
I didn't say he lied. He said that the attorney general.
Some of you communicators, you must be careful of the way you are doing politics.
No, hold on.
Did I say
what
he lied?
Did you say? You said that. Listen to me.
If you didn't listen carefully, then I will repeat.
You said that the attorney general miscommunicated to the people. What do you mean by the attorney general miscommunicate? When you yourself have not adduced any evidence to that effect, the attorney general
you have not even
was
read
not in any
Department of State report. That's why you are talking the way you are.
Let me make.
You've not read it.
Let me make my point.
Sandra, you need to read before you come to such a program. This is a big.
No. It is very important. So what is his evidence? The attorney general was not already engaging the U.S. even before the extradition process started. Did he adduce any evidence? No.
Why would they?
And you did not even question him. You understand the point?
Details.
No, hold on. But you are saying you are on a national platform and you are making an allegation against the attorney general of lying to the state without you producing.
Even what has that got to do with the constitution?
You understand? So I'm saying that what he said was not fair to the attorney general. First of all, was not fair to the attorney general. He must retract it. Secondly, like I said, we must not encourage a situation where people who are supposed to face accountability give all manner of excuses and hide behind the constitution. Just like Mr. Martin Pebu said. So what's the use of extradition? If we can just sit here and say that the person has decided not to come, so trial must continue in absentia. That is the whole point I'm making.
Okay. But your point is premised on your expectation.
Yes.
But then it appears from the constitutional provision we read that it is permissible because of that clause which says that it may take place in his absence if he refuses to attend trial for the trial to take place in his presence. So there is an exception there.
The state also has all other avenue.
Absolutely.
Just like Mr. Martin Pebu intimated that.
Yes.
That is the reason why there's what you call extradition.
Absolutely.
So if the state believes
so
that
I believe
it is important that he comes for the trial, the state can, use
force him to
every
come.
other avenue for him to come. And it is not out of place. That point must be made clearly.
All right. Yes. Absolutely. Well, thank you. Dr. Aye, Bracco Powers, I know you want to respond, but I'm not going to let you do that now.
That's fine.
You may do so if we have a bit of time after we're done with discussing the matters that we have tabled to discuss this morning. So we'd like to go straight into the Professor H. Kwesi Prempeh's Constitution Review Committee's report, which they presented to the President, His Excellency John Dramani Mahama, on December 22nd. Now, we've gone through a lot of the recommendations that have been made in respect of the number of years a term of presidency would last, and so on. But today, we want to turn our attention to the call to delink some private organizations from the Constitution, the organizations which have been mentioned specifically, and that includes the Ghana Bar Association, the GJA, among others, in the various articles listed. So this particular recommendation, if you have the full report, you find it at 9.5, all right? 9.5, clause 9.5. And it says that the committee recommends amendments to the Constitution to remove all direct references to specific private associations